202.
Hello? Hello?
Yes, ma'am. I was calling for James Pewitt.
James who?
Pewitt?
This is Jim. You know this is Jim?
Yeah. Oh,
Okay.
no. A Jim. Okay.
Hold on. Let me see if he in here.
No, that's not. That's no.
Yeah.
I shouldn't have hung up.
You've reached James B. Pewitt LLC. You can leave a message for me here, or you can try my cell, 205-612-1140.
Hey, James. This is Trenton Garmon. I hope you're doing well. Calling about Garmon v. Google. I haven't seen anything come back from the judge, but maybe he's mailed out an order. I'd like to talk with you about settling it because it's been pretty much cleaned up and mitigated as well as can be done considering Google's algorithm. They can't do anything about third-party pages. And I think most of that fake news has been corrected with other third-party pages. But if you want to continue to litigate, then, maybe the judge will toss it, maybe he won't. I think it's a good time for y'all to consider, since it's been somewhat mitigated, us getting this thing resolved. And Google just taking under consideration my claims because these are discriminatory algorithms wherein they take class-based protection categories and they factor in positive and negative based on that. But it looks like most of it's been cleaned up. I'm sure you've advised them properly. The coders are not intended to discriminate against Christians or Catholics or Muslims or Jews or honkies or whoever. But those factors are built in there. And so I would like to get this thing resolved. Let me know. It's April 2nd. Haven't heard from you in a while. Please be with you at 256-393-8717. Bye for now. Just to give a little context, I sued Google because they have discriminatory algorithm factors that are built into how they profile people in a search engine optimization algorithmic response. And they've since changed some things. The other basis of the claim was a knowledge panel had inaccurate information and they were unwilling to change it over a persistent time period with reasonable notice. And they have since changed that as well. There are third-party, like major news networks and things like that, that built stories on other fake stories, but some have been removed, others are suppressed under the corrections that we put out there. But anywho, that's my case against Google. Still doing my coding because I think that our digital civil rights are under major attack by big tech and that our government's failing to properly regulate it. There's not a systemic means through which government globally, obviously there's no global government per se, but at the national level can work with other nations to monitor the internet and to otherwise regulate it with this AI. Specifically now that AI has become open learn. LLMs are models of language that are built into AI that then can go crawl and add to if it's an open crawl type AI where it will take information from the web and sing that into its LLM responses. So it's important that we're mindful of the accuracy of things online and make changes to our law with regards to the difference in New York Times versus Sullivan, the newspaper case. and ongoing defamation, which is persistent and active, because those are fundamentally different principles with regards to law. A paper ends up deteriorating or being burned or thrown away. But this digital web is definitely for different categories of people, those who are considered public figures and just regular citizens, us common folks. It is a negative rabbit hole, I think, of bad information in some regards that's needing to be mitigated through litigation. And also accountability for these sites. If the news site has fake news, it's still up, then the posting date could actually even be modified or altered. But the point is, if it's still active, it's published for that day. It's fundamentally different than the intention of New York Times versus Sullivan. So most of those have been removed that I have sued for, but I haven't sued everybody that needs to be sued. It's a news outlet because some of it doesn't even matter. But anywho, that's my concern about algorithmic discrimination, big tech's breach of our digital civil rights, primarily including privacy and right to reputation. And that's based on my suit called James Pewitt. Trying to get the thing resolved because I really don't want to spend time litigating against Google and their team of lawyers and all their coding bullshit that changes every day. So to prove the case to jury would not be that difficult. But the point is, the learning algorithms and the way the web is alive, these claims have been proven by way of themselves. It's just a question of damages. And sometimes the judges don't care to let them proceed if they don't see the damages to be significant. They have to kind of feel the damages. But this has been out there for a while, typically motions to dismiss, which are dispositive motions, meaning it could toss it, and most of summary judgments, when it follows it, are ordered on within 30 to 60 days. Depends on the judge, but we've been waiting, and I haven't seen an order since, I want to say, like November, December is when we briefed. So the judge is not sure what to do, and I hope he's not relying on his clerks alone. I mean, they can give good feedback. The reality is my claims are true, accurate, proper, and right. My evaluation of the living web and the dark web is true and accurate, and it's true and accurate through the discriminatory algorithmic factors that take into consideration protected class according to the United States Code 1983 Civil Rights Act. And those are violations.